this is one of the most common questions, and we'll dive a little bit deeper. Obviously, it's not going to be the full fleshing it out, but one of the most common questions I get, and this a lot of times is within the false allegations, the flimsy allegations, or if they just make general in the custody dispute, substance abuse, violence, whatever it may be. So I'll start with you, Keith, and then we'll go to Brian. So in my opinion, the most powerful mechanism we have to start figuring out information is written discovery. We have the interrogatories, request to produce, request to admit. So someone comes in on a custody issue and they've levied, I call it the Holy Trinity, the substance abuse, the mental abuse, and the anger issues. And they allege all these things. How can a dad leverage these written discovery tools to at least start their fact-finding expedition?
Well, of course, your investigation, if in a cost-effective manner, written discovery is great. I want to start off with the weakness here, which is evasive discovery response. I think the reality of it is, and why you need to hire us to do a deposition, is because it's far harder for her to evade my questions in my office. Reality of this is, time and time again, what you're going to find is that when you ask questions in written discovery, they're going to give you whatever they pull out of their ass as their answer. And it's, and then I've got to litigate written discovery. I've got to send deficiency letters. I've got to talk to their lawyer under the statute. I've got to talk to them before I'm going to file a motion for sanctions. But, at the same time, Mark, I understand what you're saying. Obviously here with production, I get to say, hey, give me this. That proves what you're saying. Interrogatories, I get to say, hey, not as good. I usually use interrogatories more in a financial and or a list witnesses aspect, but admissions, probably the most important aspect of written discovery is admissions. And personally, I send production interrogatories and I do deposition before I send admissions. And here's why. Because I'm not asking you to just admit shit. I'm asking you to admit stuff I can already prove. And I can prove it. And now, if you don't admit what I'm saying, there's going to be penalties associated with not admitting it. Request for admission, the most important piece of discovery, the last piece of discovery. Did I answer your question, Mark?
Yeah. I think that points out to one thing in particular: having a professional that understands the strategy behind it. So I agree with you. Request for production can be extremely powerful to start out with, because you're going to force them, like you mentioned, financial. Hey, give me your bank records. Hey, I need to see your Cash App account. I need these records, or it could be documents. There are a lot of times I've noticed when things get nasty where they withhold documentation, they hide documents, they destroy documents that are actually property of the other party. Well, now we're going to put it on the record. We're going to put it in discovery that we need you to turn over those documents. And in California, a lot of times you can ask for them to turn over any evidence they're going to use at trial. So then when they come around at trial and they show you something they didn't produce at that time, oh, did we find this between the request and trial? Did we create this between the request and trial? It can create some doubt. And I think depositions, extremely powerful. I think the biggest challenge, I don't know if you guys see this, is the cost. It's going to cost a couple $1,000s to bring them into the office. Obviously, there's going to be prep work for it. You got to have everybody in there that's going to be necessary, the court reporter, all that stuff. So if you can gather some information and then you get them on the record, because, I mean, Keith, you said you're a prosecutor. You rarely would ever put someone on the stand in other areas of law if they haven't been deposed. Like, If there's a multi-million-dollar business litigation case, every person that goes on the stand is going to have been deposed. Like, no one's going to go on the stand, but family court, we have this pay-to-play system essentially in place that prevents the full finding of information.
Yeah, I couldn't agree more. Pay to play. Yeah.
Yeah, there seems to be a lot of. I mean, I don't even. I would go further and say there's one area of law where you have trial by ambush.
Yeah,
it could seem that way, particularly on your protective order document.
Oh yeah, and in fact, there are plenty of there are individuals. I won't say plenty of individuals. There are individuals who will try to leverage the trial by ambush strategy in protective order court with this idea that, well, I'll just blindside you.
Yeah, goes back to what I said. They show up, they filed pro per, and then they have an attorney when the hearing rolls around, and the attorney's got a binder full of exhibits that you've never seen before.
Yeah.
And
not only that, you get a court-appointed lawyer when they're drafting their affidavit. They get to go to the Divis lawyers over there. They walk them through what they need to write, and then they show up.
Yeah.
So they're getting a free lawyer while they're prepping this thing, while they're lying their ass off, calling you some kind of a dickhead, and then you get nailed when you show up to the hearing.